Good morning. I am Jayashree from Institute of Sai. We will continue with the sections of CPC. We are on to the section number 137. We are doing the sections under the miscellaneous. Okay. So whatever comes apart from the main sections, it's not, you cannot call it as main section and miscellaneous, but we are just looking at the topics. So these sections which we are doing now come under the subheading of miscellaneous. Okay. Now we go on to section 137. Language of subordinate codes. What should the language of the subordinate codes be? It will be usually in the language which has been followed over a number of years. Okay. So obviously it will be the vernacular language. What do you mean by vernacular language? Anything which belongs, any language which is the official language of the state or which is widely spoken in the state. Okay. Vernacular means local, the regional language. Okay. So every state will follow the vernacular language, the local language. But it is not compulsory that it should be only in vernacular language. Okay. The state government may change the language at any period of time. So it can be the language in which the state government directs to use, or it can be the language which has been used in the courts over a period of years, or it can also be English. If any of the pleaders or the parties or anybody is not comfortable with English, it can be in any other language, that is vernacular language, regional language. Okay. Okay, where you can just go to the subsection 3. The subsection 2 and 1 I have already explained. Where the code requires or anything or allows anything other than the recording of evidence to be done in writing, such writing may be in English. If it cannot be in English, then it can be regional language. Okay. So then we go on to section 138. Power of High Court to require evidence to be recorded in English. The High Court has the power to make rules saying that evidence should be recorded only in English. See, sometimes what happens, this is not like we are taking English to a higher level, or we are giving preference to English. It's not like that. What is the main concern? See, India has a variety of languages and all, culture and all that. Basically, all of us know that. But when it comes to courts, we are bothered only about the languages. We are not bothered about any culture or anything, right? Because law is the same for everyone. Okay. So when we are talking about the courts, if English is not possible, then it can be in any other regional languages. But High Court may say that evidence should be taken only in English. Not everybody knows the regional languages. Nowadays, trade has gone on to, we have interstate trade and online marketing. There are so many things, So everybody will not know all the languages of India. So in that case, it may be taken in English. Okay. So there is no prohibition that English should not be used in the courts. Then section 139, oath on affidavit by whom to be administered. All of us know we have to file an affidavit whenever there is a need, where there is a direction by the court or where there is a direction by the acts which we are studying, we have to file an affidavit. And those who are practicing already know that for every application that we file before the court, we have to file a supporting affidavit. Right? Along with the plaint also, we have to file a verifying affidavit, correct? So, who can administer an affidavit? When we say administer, that means what? Put the seal and sign, notary, right? We'll go to that. So, who can administer an affidavit, oath on affidavit? Any court or magistrate. Any court or magistrate can administer the oath. Okay. See, when we are filing, why it is written as court or magistrate, I already told you notary, because that is the usual thing, right? So when we say court or magistrate, who can administer? See, when we are filing an affidavit before the court, we swear before the court. Am I right? We say nothing but the truth and all that, So we swear before the court saying that whatever is written in the affidavit is true and correct to the best of my information, knowledge and belief, right? So, who can administer? Number one, court or magistrate, or any notary appointed under the Notaries Act. Why is it written any notary appointed under the notaries? It can be notaries of the government of India or any the same. Third one, any officer or other person whom a high court may appoint in this behalf. See, sometimes what happens when we are getting an affidavit done, probably it needs, it is in the nature of an affidavit. So probably, even if it is say some gazetted officer or something like that, even that would do, right? Then fourth one, see, any officer appointed by the other court which the state government has generally or specifically empowered in this behalf. So where the court, okay, where the officer has been appointed by any other court, saying that now this person who is sitting in the court shall administer the oath on affidavit, then only that particular officer who has been given the delegation shall be allowed to administer the oath. Clear? Then next we go to section 140. Assessors in causes of salvage, etc. Okay, in any admiralty or vice admiralty cause of salvage, towage or collision, the court, whether it be exercising its original or appellate jurisdiction, may, if it thinks fit, and shall upon request of either party. This is nothing but surveyors, When we say assessors, it is the we have been reading, we read about the commission part, am I right? So whenever there is a salvage means what? It's a damage and it's only a debris. How much damage has been done to a particular property or asset, or, it can be a mobile property or immobile property. But what is the nature of the damage? How much the damage has been caused? Okay? And what are the consequences of the damage? All these has to be assessed. Okay? And sometimes what happens, all this has to be calculated. To what amount will it come? See, if there is say for example, we have all this fire insurance, theft insurance and all these things. Am I right? So when it comes to recovery of money from the insurance person, from the insurance company, then the assessor will be appointed to know what is the damage which has occurred, how much is the damage, and how can it be quantified. So that the insurance, it will be easy for the court to determine the amount which the insurance company has to give to the party. Okay. So for that, assessors have to be, they should be appointed, right? And who will appoint the assessors? It shall be done by the court upon application by either party to the suit. It's not necessary that it should be only the party which has suffered the damage or the party which is asking for recovery of money. It is not like that. Okay. So in this case, what happens? It is the court which appoints based on application by either party to the suit. We go to section 141. Miscellaneous proceedings. The procedures provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. Okay, so what will be the proceedings? The proceedings will be as per what has been mentioned in this CPC. Let's go to the explanation. In this section, the expression proceedings include proceedings under Order 9 but does not include any proceedings under Article 226 of the Constitution. Okay, so Article 226 of the Constitution speaks about writs, right? So writs need not follow the procedure of what has been laid down in the Civil Procedure Code. Okay, then next 142 section, orders and notices to be in writing. So whatever are notices or any order passed by the court, everything has to be written in writing. Okay, everything has to be written. It is not enough if it is oral. It should be in written. Okay, then postage, section 153, postage. We know this already, but still. Postage where chargeable on a notice, summons or letter issued under this code and forwarded by post and the fee for registering the same shall be paid within a time to be fixed. When we are paying the postage process memo, right? When we are filing the process memo, we also give, sometimes what we do, we will be reading all that summons and all that. Sometimes what we do, we just send it through the court. Sometimes it is through the RPAD, right? Register Post Acknowledgement Due. So whatever it is, when there is a postage which is required, in that case, the stamp shall be affixed and the postal, whatever is the cost of the postage, that shall be given to the court. Okay, section 144, application for restitution. Where and in so far as a decree or an order is varied or reversed in any appeal, revision or other proceedings, the court which passed the decree or the order shall, on the application of any party entitled to any benefit by way of restitution or otherwise, cause such restitution to be made as will. But so far as may be, place the parties in the position which they would have occupied but for such decree or order or such part thereof as has been varied, reversed, set aside or modified. And for this purpose, the court may make any orders, including orders for refund of costs and for the payment of interest, damages, compensation, mesne profits, which are properly consequential on such variation, reversal or model. So what do you understand from this section? Whatever is restitution. What do you mean by restitution? Restitution means putting something in its own place, giving back something to itself, right? See, if a person has lost his possession, okay, and he would have filed a case for getting back the possession. So what will the court to do? The court will pass an order for giving back his rights as the possessor of a property, right? If he has been illegally or unlawfully been removed from the premises, right? Or if there is any money which has to be got. Usually, restitution comes in place of possession. So wherever it is wherever the case is for repossession, then restitution. Once the restitution order is passed, then the person shall be put in his own place. Originally which he occupied, he shall be put in that place. Whatever are the costs or any other expenses which has been dealt with, that shall be reimbursed as per the court orders. Section 145, enforcement of liability of surety. Where any person has furnished surety or given a guarantee. Okay. So where a person has signed as a surety or a guarantor, then if the debtor does not repay the amount, then it shall be repaid by the surety or the guarantor. We have already read it in the Contract Act. That is how the contract liability arises, right? So again, you have it in CPC also. Let's go through it. Where any person has furnished security or given a guarantee for performance of any decree or part thereof. See, when there is a decree which has been passed against a party, then another person shall stand in. Not shall, may stand in as a surety. Already he would have signed the agreement before the case probably. Usually it is like that. Before the suit is instituted, during the loan agreement or the liability agreement which is made. Okay, so the guarantor or the surety signature will already be there. So once the decree is passed, if the debtor is not able to make good the payment, then the surety or the guarantor shall make good the decree amount. For the restitution of any property taken in execution of a decree. We just saw that, right? So in case the person who has to give back the possession is not there, then the person who has stood as a surety or guarantee can give it back. For the payment of any money or fulfillment of any condition imposed on any person under an order of the court in any suit or in any proceeding consequent thereon. So this is in case of recovery of money, that we know very well, am I right? There's a creditor, debtor or creditors and a debtor, and there shall be a surety or guarantee. Obviously, he'll have to repay if the debtor does not do so. Then next, the decree or the order may be executed in the manner herein provided for execution of decrees, namely, if he has rendered himself personally liable against him to that extent. See, surety or guarantee shall be held liable only to the extent of the amount, but there shall not be any personal liability unless he has signed and he has accepted the terms that there shall be personal liability when it comes to repayment. Okay, so to that extent he can be held personally liable. If he has furnished any property as security by sale of such property to the extent of the security. Again, where any property has been kept as a security, mortgage, right? Then sale of such extent of the property in order to realize the loan amount. Third one, if the case falls both under clause 1 and clause 2, then to the extent specified in those clauses. This is very clear, right? Provided that such notice as the court in each case thinks sufficient has been given to the surety. Surety should be given sufficient notice. All of a sudden, the court officers cannot descend on the surety and say that, see, the debtor has not repaid, so we are taking away your property. That's not the way. Section 146, proceedings by or against representatives. We know whoever has the right, title or interest or claim only can sue and be sued against, right? So that's the very basis. Am I right? Yeah. So here we are seeing proceedings by or against representatives. Whether any suit can be filed by or against the legal representatives, save as otherwise provided by this code or any law for the time being in force, where any proceeding may be taken or application made by or against any person, then the proceeding may be taken or the application may be made by or against any person claiming under him. So wherever the law allows, okay, wherever the code allows, there action can be taken by or against a legal representative. 147, consent or agreement by persons under disability. In all suits to which any person under disability is a party, any consent or agreement as to any proceeding shall, if given or made with the express leave of the court, by the next friend or guardian. Okay, where there is a disability. See, where there is a physical disability or mental disability which makes it not possible for the party to come to the court. Okay, then including the notice and summons, it can be served on the next friend or guardian. Okay. 148, enlargement of time. Enlargement of time means what? Postponement, right? Adjournment. Where any period is fixed or granted by the court for the doing of any act prescribed or allowed by this code, the court may, in its discretion from time to time, enlarge such period, not exceeding 30 days in total. So there also you have a cap saying that the adjournment can be given but not exceeding 30 days in total. Section 148A, right to lodge a caveat. Caveat is lodged before the High Court. What is a caveat? Caveat is a suit which is filed before the High Court when a party feels that he has to be informed before the other party files a case before the High Court. You understand? Say for example, if you look at companies, all those, especially the companies or the top management in companies, top managers, okay, what they do is, if they are of the suspicion that the other party, whoever is against them, will file a case in the High Court surely against them, then they can file a caveat. They not only file a case before the High Court, before any other court, okay, for any nature, of any nature. Then The party who is thus suspecting can file a caveat in the High Court and then say that if the other party files a case against me, I should be informed that there is such a case beforehand. Okay, that's why caveat is filed. Anyway, we will read here in thorough. Where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. That's what I explained now. We'll go to subsection 2. Where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged therein referred to as the caveator shall serve a notice of the caveat by register post acknowledgement due on the person by whom the application has been or is expected to be made under subsection. That means what, when the caveator has filed a caveat, he shall give adequate notice to the opposite party saying that a caveat has been filed. So, the person who is filing the caveat is known as caveator. The person who is whose name has been given as the opposite party is known as the caveatee. Okay. Subsection 3. Where after a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of the application on the caveator. Okay. So, any application which has been filed, then the caveator shall be informed by the court about such application being filed. Where a notice of any caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator's expense with a copy of the application made by him and also copy of any prayer. So, wherever a caveat has been filed, the caveator shall give a copy of the caveat plus the prayer to the caveatee. Subsection 5. Where a caveat has been lodged under subsection 1, such caveat shall not remain in force after the expiry of 90 days from the date on which it was lodged, unless the application referred to in subsection 1 has been made before the expiry of said period. Okay. So, caveat, the effect of the caveat, how long will it be there? The effect of the caveat shall remain in force only for 90 days, after which it shall expire. Next, we go to section 149. Power to make up deficiency of court fees. Where the whole or any part of any fee prescribed for any document, the court may allow. Okay, so it is the discretionary power of the court. Power to make up deficiency of court fees. See, we will have a certain calculation of the court fees which has to be paid for a certain case. Depending upon the nature of suit, all of us know that we will go to Suits Valuation Act. Am I right? So, Court Fees and Valuation, Suit Valuation Act. Okay. So, when we go through that, we know how much has to be paid. But sometimes what happens, we are not able to make the full payment because of miscalculation or some other reason like that. So, where there is a deficiency in court fees, the court may use its discretion and allow the party to make the balance payment of court fees. Okay. Section 150. Transfer of business. Save as otherwise provided where the business of any court is transferred to other court, the court to which the business is so transferred shall have the same powers. Right? We have done it in Evidence Act also. I mean, any act you go through, it has the same thing. Wherever there has been a transfer of the case, okay, it can be within the district, within the state, or between state to state, anything it can be. Whatever is the nature of transfer, or from which court, whichever court to whichever court it is transferred, the court shall have the same power as that of the court where the suit was originally filed. Okay. So, each court has a certain power and that power shall be used. Section 151, saving of inherent powers of court. That's what we call it as discretionary powers, right? In certain matters, the court has the discretion to pass certain orders or give certain directions to the parties. That's known as saving of inherent powers of the court. Section 152, amendment of C. When you're talking about 151, it looks very easy, right? But practicing advocates know for everything we write, read with section 151 CPC, right? 151 of CPC. That's how we write, because we are praying to the court to use its inherent powers. Wherever there is, see, just now we read about power to make deficiency of court fees, right? Where if we have paid a less amount of court fees, if the court fees which is paid is less, in that case we need to pray to the court, please give us time to make the balance payment. Then court will use its inherent power, right? Court using its inherent power will tell that the court fees which you have paid is not sufficient, so make good the balance payment, right? So that is again inherent power. So there are so many things like this. Everything comes under section 151 CPC. Very important. I mean, probably in your viva they may ask, nothing is sure, okay? So can you tell me something about inherent powers of court? So you should be in a position to explain how, what are all the powers. You cannot just put it in a, say, this point, this point, this point, but you can just give examples, okay? Section 152, amendment of judgments, decrees or orders. Clerical or arithmetical mistakes, again we go back to Evidence Act, technical irregularities and other irregularities, right? So wherever there is arithmetical mistakes in the calculation, recovery of money or anything, meets and bounds, anything it can be, okay? So where there is a calculation mistake in the calculation, or where there is a clerical mistake means what? Typo errors, right? Like how we write in WhatsApp and all that. I'm sorry, it's a typo. That's how we write, right? So any typo errors, while typing probably the word would have changed or the spellings would have changed, right? If the word has changed, then we should see to what extent it affects the order and the implementation. Otherwise, usually it is the clerical mistakes, the typical, sometimes we tend to miss out certain words, sometimes we tend to make spelling mistakes. There are so many things like that. So clerical mistakes or arithmetical mistakes. Then amendments can be made. Certain omissions and commissions. See, we have written extra words or we have omitted certain words, but the underlying rule is that it should not change the nature of the order. If it changes the nature of the order, then it cannot be taken as arithmetical mistake or clerical mistake. Am I right? So here it is only very minor mistakes which we are speaking about in section 152. Section 153, general power to amend. The court may at any time and on such terms as to cause or otherwise amend any defect or error in any proceeding in a suit, and all necessary amendments shall be made for the purpose of determining the real question or issue raised. So there can be, again, as I say, small mistakes may occur in any of the orders or in any of the writings or anything, notices and all that. So wherever it is, it can be amended by the court, provided it does not raise any major issue. Section 153A, power to amend decree or order where appeal is summarily dismissed. Where an appellate court dismisses an appeal under Rule 1 of Order 41, the power of the court to amend under Section 152, the decree or order appealed against, may be exercised by the court which has passed the decree or the order. So the court where it was originally filed, which had the original jurisdiction, shall amend the decree or the order. In the first instance, notwithstanding that the dismissal of the appeal has the effect of confirming the decree or order, as the case may be passed by the court of first instance. So where the appellate court, it dismisses an appeal under order 41, Rule 11. Power of court to amend under section 152, decree or order appealed against may be exercised by the court which has passed the decree or order. So whatever it is, who shall Who shall amend the decree or order? It shall be by the court which passed the decree or the order. Okay. Giving such directions, the appellate court will dismiss the appeal. Section 153B. Place of trial to be deemed to be open court. Deemed to be means what? It shall be automatically assumed, legally assumed. Okay. So, place of trial to be deemed to be open court. What is open court? It is not some open area. It is the court hall. Okay. It's not, why we call it as open court is not because it is not a very small place or chamber of the judge where the case is heard. It's not like that. It's an open court. It's in the court hall. Anyone can come, anyone can go out. That's why it is known as open court. Then, section 154, saving of present right of appeal, it has been repealed. Section 155, repealed. Section 156 also is repealed. Section 156 ironically speaks about repeals which has been repealed. Section 157, continuance of order under repealed enactments. See, continuance of orders under repealed enactments means what? Wherever an order has been passed under certain acts which have been repealed, okay, they shall be in force till such time till the state government or the central government says that it shall be in force. Okay, so we'll just go through it. Notifications published, declarations and rules made, places appointed, agreements filed, scales prescribed, forms framed, appointments made, and powers conferred under Act of 1859 or under any code of civil procedure. See, Civil Procedure Code since 1908, that's the original one. Since then, it has been amended so many times, right? So, obviously, orders would have been passed under all those amendments. Clear? So, it shall be in place. Okay, or under any act amending the same or under any other enactment hereby repealed shall, so far as they are consistent with this code, have the same force and effect as if they had been respectively published. So, wherever there is an order which has been passed under the previous amending acts of CPC or the original act of CPC in 1908, okay, so original code of civil procedure 1908 or the amending acts, whatever it is, the order shall be in place. It shall be effective only to the extent that it is in what do you call it as? It is in it is consistent. It is consistent with this particular code which is in force now. Okay. So only if it is consistent, that is, it goes along with it, complements this code which is in force now. Only up to that extent those orders shall be in place. If they are not consistent with this code, then which is in order, which is in place now, then they shall be extinct. Okay. Then section 158, which is the last section of CPC. Then we conclude this session. Section 158.